If the person is a casual, I think what employers, if there are employers out there that are employing casuals now, and they're under the assumption that they enjoy the protections that employers usually have with casual employment, that might be wrong. That might be a risk to them as
Welcome to the Business Behind Your Business, conversations to help your business grow and thrive. Hi, I'm Paul Sweeney, founder of Pretium Solutions, Chartered Accountants and Certified Business Advisors, hosting the Business Behind Your Business. So welcome to the Business Behind Your Business, and today we're looking at an issue for employers, and I've got Philip Vandenhever from Frank Law, and Philip does a lot in this employment law area, and I've also dragged in Paul Cripps, HR specialist from PK People Solutions. And the reason we're going to be talking today is there's this issue that's come to the forefront. It's to do with a case concerning casual employment, and it's really got the potential to change the way that employers look at casual employment. So Philip and Paul, welcome back to the show. It's great to have you on again. So before we actually look at this issue, can we just put in perspective what is casual employment and why? Why do we have casual employment? And then once we understand that, I think we might be a better place to understand what this issue is going to be.
Yeah, thank you, Paul. And you're absolutely spot on, because I think it's really important to understand in terms of what it actually is. From a practical point of view, I might let my friend Philip talk more about the legal side of it in a bit more detail. But from a practical point of view, casual employment really is very much there to help employ people on an ad hoc basis. It's not. It shouldn't be regular hours or regular days, and that's really, I guess, where casual employment was actually born from. The idea is there's no commitment to ongoing work, and apologies if I'm using the legal expression there and doing that, just stuck in my head. But the one thing that so the employers get the advantage is there's no ongoing commitment to the employee for ongoing work, and in return, the employee gets compensation. It's usually looked at, we look at modern awards in terms of 25% loading based on their role on top of their salary, and that is there to compensate things like entitlements to personal leave, which we sometimes call sick leave, and annual leave, and other leave entitlements from there. So really and truly, it was really down that the key thing really is there for ad hoc work as opposed to consistent ongoing work. Having said that, it's really probably over time morphed into being used in a lot of other different ways.
Look, I can think of plenty of instances where employers have brought on somebody as a casual, and then over time those casual hours have been consistent from week to week, year to year, and suddenly somebody's been there 4 years as a casual.
Absolutely.
I'm thinking we could have a few issues there.
Absolutely correct, Paul. I think it's exactly what has happened. I think that I've come across multiple examples of that over the years where that's exactly what's happened. People have been working really in what is actually a permanent full-time role, with consistent hours, with consistent days, and really and truly they're actually filling really what is a permanent role, and that's where we get into the territory where you could argue that there is we're really probably incorrectly classed as casuals, and certainly one of the things that we're going to talk through today is around how employers should look at that and identify who those people are and decide what action they should really take at this particular stage on that.
Yeah, Paul, thanks. It's great to be here. I might jump in there, and I'd like to say that it's exactly because of this change of use of employees over time that have created this legal problem, so to speak. As Paul has said, the entire idea of having a casual was not to have the commitment, long-term commitment. In other words, the employee doesn't have this expectation of ongoing employment, which also meant that he didn't have really recourse to unfair dismissal and some other entitlements. And employers then employed people on that basis on the presumption that they have those protections and that they can terminate the employment at any time, and not for any reason, but relatively more easier than that of a permanent employee. And of course, but the law has caught up with this type of conduct over time, and that has basically resulted in the matter of a Mr. Rosato, who was employed as a casual employee and was offered permanent employment by his employer. I think it's West Truck was the employer. Might be wrong on that one, but and he refused that for a number of times, and then eventually the matter was before court, and he said, well, actually, if you look at the way I was employed, the continuing, I had some certainty about my roster, therefore I'm actually entitled to the permanent employment entitlements. And the court agreed. The court agreed that, despite the fact that there's a casual employee agreement in place, if you look at the nature of the relationship, the way he was rostered and used in the business, he's entitled to be a permanent employee, and those protections which the employer thought he had did not exist. So that has caused a really problem from a legal perspective.
So I'm seeing a bit of an issue there, because on one hand we're classing him as a casual employee and saying, look, you're getting a loading because you're not going to get your entitlement to annual leave and personal leave and long service leave. But on the other side, we're saying, well, the nature of your employment is that you are a permanent employee, so you have the protections of an employee, but there's an issue, I think, there in what is his entitlements to annual leave and personal leave and long service leave, but also he's being paid at a different rate.
That's exactly right, and this is exactly why the government actually came on board in this matter as an interested party, because it realised that the government said it will costing businesses an estimation of $8 million in accrued leave entitlements. And what the court has found in that specific argument, because that's exactly what Westrack said, they said, all right, if he then was unfairly dismissed and I need to pay out accrued entitlements, I need to pay out a compensation based on a certain pay rate. It should be his pay rate that he receives less than the 25%, because that is what I would have agreed with him. And the court said, no, you agreed to X amount pay rate, whether that is 25% above the award or not, doesn't matter. So it's a bit of a double dipping. This is exactly what the government feared would happen. The matter is before the High Court at the moment, and it will be heard later in this year. There's not a specific date set down yet. But it will be, we are in this era of where there's a little bit of uncertainty about that aspect, and businesses could be exposed. There's no doubt about that. The Morrison government about 2 or 3 weeks ago announced some changes which they propose to introduce as a result of this Rosato matter, and one of them includes the ability to offset the 25% casual loading against any accrued entitlements that the person might be entitled to if he was employed as a casual and later it is found that they are not employed as a casual. So it's legislative changes like that to attempt to protect employers, but it still has to go through Parliament. There's no doubt that the Labour Party and perhaps the unions will likely object to this legislation. There might be some changes, we don't know. So we are a little bit in this uncertain times when it comes to casual employees.
And look, employment relations are very often on a knife's edge and sometimes strained. And we also see a lot of small and medium businesses employing friends or somebody that's been referred to them, and
or relatives sometimes regularly.
And that casual basis is really quite attractive. Now, Australians, I guess, have a love affair with the loading and the extra penalty rates. So, as an employee, being employed on a casual basis, I'm sure I'm going to have some resistance to being told, no, you're not going to get paid as much and you're going to have all these requirements. So, what other issues are we going to see coming through with this?
Yeah, look, I think that, as Fitzgerald said, we are in this uncharted or uncertain territory really at the moment. What I am seeing, though, is employers starting to think more carefully about the employment relationship at the start. So, I've got employers and I'm advising employers, it's very much to think about, okay, so this role you're employing this person, is it really casual? What's your resistance to taking this person on a full-time basis? And sometimes it comes down that, well, okay, if it doesn't work out, then I'd like to be able to terminate the employment without going through what they consider to be they think it's impossible to terminate somebody, and it's difficult. It comes with its challenges to terminate someone. There's no doubt about that. But some of the advice that I often find myself giving, and obviously it's on a case-by-case basis, say, well, okay, so if you're going to employ someone, if you're a small business, you're protected by the Small Business Code, which is 15 people or less. And there's got to be careful there as well, because sometimes that's associated entities as well. So always make sure you get some advice on that.
And is that full-time or
no,
just
that's
any type of employment relationship.
So
and that will give you protection for 12 months.
Correct. Well, it's 12 months, and there's, of course, the business code,
yes,
which is a kind of a checklist that you need to follow, which, if you follow the checklist, you will be protected from unfair dismissal. So you're right, Paul. Businesses need to think a bit broader than what they think protections might be, because there are already some protections built in the system to protect small businesses, particularly in this regard.
But the other thing as well is that even for businesses beyond that don't fall under that cap, there's still protection of a probation period. And having a good clause in employment contracts for probation periods is important. So it gives you the ability to terminate some within that period of time.
That's exactly right, Paul. And I always say to clients, if your employee don't impress you in the probation period, he's not going to impress you after the probation period.
Yes, that sounds like conversations I just repeat myself constantly with a tape recording.
I mean, if he or she is not going to impress you during the honeymoon period, don't think things will get better. Make your decision early about whether or not the person is suitable to your work. It is so much easier to make that decision early before probation ends than a week before or 2 days before probation.
Absolutely right. Absolutely. The one thing I guess, I'm just picking your brains on this, but really is the one thing I often suggest is I do suggest to employers they look more at a 6-month probationary period rather than 3. Yeah. That's been my advice consistently now over the last few years. Because if they can do it, why wouldn't they?
Exactly. It just takes the pressure off, right?
It does.
Because for the first 2 or 3 months, it's anyway training, and obviously depends, what the type of role is and what type of business it is. But for most part, the first 3 months is really training that you give leniency to the person in terms of getting used to your systems, processes, and how you do things. But you're right, Paul. A longer probation period definitely puts the pressure of you to make that decision. But we do encourage you to make that decision.
And look, one of the questions, and I think this is probably another topic that we can go into in depth, but does an employer need to be careful of a process or make sure they still follow a process during that probation period? Look,
I think that there is more leniency. And my view always, and Philip will tell me whether this is law or best practice, my view is always at least make the employee aware about what the issues are. Some of the wording I suggest that employers use during the probation period, if all is not working well, but they're not quite at the end yet, is so look, have a conversation with them, explain to the employee what's not working correctly, and so look, you are during your probation period at the moment, we need you to improve on this within whatever the time frame might be, whether it be 1 week, 2 weeks, whatever's reasonable, but give them an opportunity to change before actually just going in and having that first conversation to terminate. Now, having said that, I think, Philip, you can explain a bit further here. The law is a little bit more lenient on that. I tend to think that, from an ongoing group employee relations perspective, you're better off going down the best practice route, at least having one solid conversation. Otherwise, you could end up with issues as an employer about how you're perceived as an employer.
Correct, and I think also, Paul, you're right. It is, the law is a bit more lenient on that. You really don't need to have extensive reasons during a probation period. Yeah, you need to give the reasons why you terminate someone, but you don't have to necessarily go through the process of warning, etc., etc. But Paul makes a very good point that it is best practice. Why is it best practice? Because you as an employer are also, it costs you money to employ somebody, right? It takes your time, it takes your effort to train them. So you don't want to repeat that. You don't want to go find another person. So you want to use the probation to your best of your ability to try and make it work. Now, if it doesn't work, make the decision and let it go. But the best practice that Paul is really talking about, it's not just for that employee's benefit, is for your benefit as well, because to really see if this employee is adaptable, can he change, can he fit in with our culture, because it costs you money to start over. In other words, terminate him and get someone else again. So it's not just to the benefit of the employee that you do that, it's also a benefit to the employer to actually do that. But the law doesn't strictly require it.
Just, I think the one thing there, Philip, if you don't mind, just in terms of reasons. My view is in terms of reasons, you don't have to be as detailed as you would do with someone that say that basically is past probation. Giving a reason, I tend to think that's you actually give a very limited reason.
Correct. And can be a broad reason as well.
Exactly right,
a cultural fit, or
Yeah.
Not suitably qualified or trained or skilled to perform the job or something like that. That should suffice. But it's good practice to give a reason why, to give the employee also some direction of what the reasons are.
Mm-hmm. So we're looking at probation period in here. We're probably more talking about permanent employment. So we still have this idea that casuals are, I hesitate to use the word disposable,
Yes.
but in some cases it appears that way. So, but you can terminate a casual's employment a lot easier, it would seem. So as an employer going forward, what are some of the key things that I need to be aware of, regardless of whether this legislation comes through, because I think there's still going to be an issue underlying there about whether it is actually a casual or permanent relationship. But what are some of the things as an employer I should be mindful of, particularly?
Yeah, well, I certainly think a part of it is in working out. So what is actually needed? Is it a casual arrangement, or is it really a permanent role? I tend to take the view that if you're actually looking to trial someone, if you want to trial someone, it's a permanent role. Just put them on a permanent contract on a probation period is my view. And I had an example a few months ago with a client where that went wrong because they brought on this person as a casual. Everything went well after a few months. They gave them a permanent contract. But what they did, they forgot to change that person's pay in the payroll system. So for a number of months, the pay was going, and this person was obviously not looking at their pay slips and not enjoying what was in their bank statement. And all of a sudden, it came out in the wash when they did their annual remuneration review that, my goodness, why is this person paid so much? So even things like that, where it can go wrong. So I always say, look, if it's very much down to if it's casual and there are ad hoc hours, absolutely fine. Maybe also if it's going to be really, it's a limited term. It's only going to be for a period of a few weeks or a few months, seasonal work. Work for a particular project that's going to end. That's absolutely fine. But if it is actually a full-time role, just make it a full-time permanent role. And make a judgment there. I think if it is a casual, and it is a genuine casual role, Philip, do you want to comment a little bit about some of there is some definite wording that should go into contracts?
Yeah, that's right. I mean, if the person is a casual, I think what employers, if there are employers out there that are employing casuals now, and they're under the assumption that they enjoy the protections that employers usually have with casual employment, that might be wrong. That might be a risk to them, as you and I spoke a bit earlier, Paul. It might be that there's an accrued liability that they don't even know about. And that is the issue. If you use your casual employee, the courts use the words on a regular, certain, continuing, constant and predictable manner, it is likely that that person will be deemed a permanent employee, and you will have an accrued liability for the duration of that person's employment. So that's the first thing that they need to be aware of. The second thing is, in this interim time, while we don't have legislation, it's draft form, we don't have a High Court decision. That's in the future, we don't know which way that's going to go. And I think if the government already puts in legislation, I think that kind of tells you what the government lawyers think the High Court's going to do, right? And I think most employment lawyers that will have looked at the Rosato case would say, the 3 judges in the federal court was probably not wrong on this matter. So there's definitely exposure. What can you do? You can have certain things in place to try and protect you. You can have a clause in your casual employment agreement which says that any casual loading that's on top provided can be offset against any future entitlements that you might be entitled to if you are deemed by a tribunal or whatever to be a permanent employee for your leave entitlements. Now, that's not been tested. That is my suggestion in the interim to try and protect yourself from it. But I think that will go a long way to try and protect businesses from this possibility.
And look, one other thing that comes to mind is that a lot of, particularly newer businesses and small businesses that do use a lot of casuals, you mentioned employment contracts, they still seem to be missing in action when you talk to a lot of business owners, that they just don't have them. So I'd have to say that you've got to review that situation, and regardless of how short term the casual employment is going to be, there's got to be a contract.
And it really isn't a costly thing, is it, Philip?
No,
to get something in place like that. I mean, but it just gives so much protection. If you have something in place, and the amount of times, and I'm sure Philip will say, you come across issues where there is no contract, and it really can be problematic. And look, it really, it shouldn't be anything. If you're actually going down and you're actually employing people, you should think about actually budgeting a cost to put a solid employment contract and a pack of policies in place. It's not an expensive thing to do, but it really is the case of something you should just budget as part of, I'm employing people now, I need to put this in place. Otherwise, people will come unstuck.
Paul, I apologise in advance if I do a plug-in, but we actually have a free casual employment template on our website available for people to download should they wish to go and check that out.
Yeah.
So Paul is absolutely right. It is a small expense to have employment agreements and policies that accompanies them, that protects you. It is when it comes to agreements, they largely, once they're formulated, they can be templates, they can be really useful to you for a number of years, whereafter you need to review them again. The same with policies. Policies are a bit more fluid. They might change a little bit more regularly, but the point is, once you have them, it's easy to update and keep updated.
Yeah.
That is not that. It's classic, one of those things. Just do it, and it's there in the background, and it runs its own course. So, and employment agreements do go a long way to clarify people's rights, to clarify what they're entitled to. It also goes a long way should you wish to discipline an employee, take appropriate performance management steps. It just makes life so much easier. There's not just when it comes to termination, but just other types of issues as well.
Great, fantastic. So we'll put a link to that agreement in the show notes, because I think that's really important. Because just before you mentioned that, I was thinking that we've got to be careful, because a lot of people go to the internet and pull down an example contract or a Word document, and they're not aware that the legislation referred to in that nice little template they found isn't appropriate, doesn't actually exist. And that's why you need to get something prepared by a legal firm that is actually dealing with Australian legislation.
That's right. So in terms of, we regularly update the template to make sure that it's up to date. We give detailed instructions how to complete it, number to call if you don't understand how or what to do. So, you're absolutely right. Just dragging templates from the website. What people need to see.
I've seen some bad examples where that's gone wrong.
I think the problem especially is when you do that, what Paul's saying, just go to a website and drag a document down, and then you add stuff to it. The danger is that you might create legal obligations on you that you never intended to do.
Yeah.
I always take the example of a term in your employment contract that says, you will be provided with a laptop in the employment contract. It's a legal right? So for a time period, your laptop is broken, the employee can say, wait a minute, I've got a... Or, the person doesn't need the laptop. Laptop is probably not a great example. A fuel card, a motor vehicle. Yeah. You might want to say, you don't need a vehicle more, I'm going to take that vehicle, give it to somebody else. Yeah. Paul can say, wait a minute, my employment contract gives me a right to a motor vehicle. Right? So you might create legal obligations that you did not intend to create as legal obligations on you. So, it's important that those agreements are reviewed and
I think it is a case of having wording in there that thinks about the future, and I always say the unintended consequences of having something in there. And Philip, I think you agree as well. Sometimes actually less is better. Sometimes not having things in there can very much ultimately work in the favour of the employer, as opposed to if things are too explicit.
Yes,
and require
absolutely right. That's exactly right.
The
Paul.
example that Philip's quoted there, where there's actually too much information there that comes back to halt an employer down the track.
Which could be in your policies and procedures.
Right.
You could have a letter to the person say, look, you may be provided, subject to our policy, to a motor vehicle.
Yeah.
And the motor vehicle say, you're not entitled to a motor vehicle. It's at our discretion. We can take it when we want to take it. And it's got nothing to do with contractual rights.
And Philip, if you can just confirm something for me in terms of policies can change.
Correct.
And policies aren't contractual.
Correct.
So an employer has a lot of flexibility there in terms of changing a policy down the track.
Correct.
Whereas a contract is a lot harder to change.
Requires agreement.
Right. Okay. So just summing up, we've got this issue that we need to identify whether we actually need a casual or a permanent role. That's really a first step.
Absolutely.
We need to have the documentation in place. We need to have a contract.
Yep.
We need to understand our rights as an employer, and also what your obligations are. We need to make sure our payroll is correct.
Yes, which sounds so simple, right? But it's because I've seen it go wrong. I thought I've got to share that example because it does go wrong.
Yeah, we get a lot of inquiries where we have to go back and reconstruct payroll because annual leave wasn't accrued correctly.
Right. Yeah.
So there's some key things there. And look, I think these are things that every employer, every business needs to have in place regardless of the outcome of this court case and the legislation, because I think it's just sound business practice. And I think I'm going to add a fifth point there, is that most business owners aren't employers or HR specialists, and this is where there's a risk. So unless you are suitably qualified in those areas, it makes sense to get the right advice, from somebody that is an expert in that field, to make sure that you're not exposing yourself to unnecessary risk in your business. So,
Absolutely.
Yeah.
Absolutely right.
So, just summing up, what are the key things? Well, we went through those points, but is there anything that you would urge business owners to get in place right now?
I think you've covered a lot of it there, Paul. I think in terms of the points you've put in there, I think the only thing just to add there is for business owners to not be too afraid of taking the plunge and employing someone on a permanent basis. But if they're going to do that, make sure they've got a good contract in place. And if it's a casual, make sure they've got a good contract in place. Yeah. Philip's obviously explained in terms of where there's a template people can get hold of for free. And it's so important to get it right up front, because that to me I think probably was one of the key things I've added to the points you raised.
Yeah, I think Paul talks about new employees, and I think on the same terms, take the plunge and review what you have now in place.
Yep.
Because as we said, you might have an accrued liability that you don't even know about. Talk to your accountant about that. Talk to your legal advisors about that. How do I change it? How do I correct it? People often think, I'm in trouble there. And what do? They avoid it. Yep. Pretend it's like the elephant in the room. I pretend it's not there. No, face it, deal with it, fix it. It's possible.
Great, fantastic. And so if our listeners want to get in contact with you, we mentioned the website, we'll put that in the show notes, but particularly where's the best place to contact you, Philip? Yeah,
best place for me to contact me is really my email address, which is Philip with one L at franklaw.com.au, which is also our website address, franklaw.com.au. And Paul, just again, thank you for the opportunity. Really appreciate being there. Thanks, mate.
Great, fantastic. And Paul Cripps, how do we contact you?
Yes, so for me, email address is paul at PK, it's P for Paul and K for Kenneth, pkpeoplesolutions.com.au, and the website address is pkpeoplesolutions.com.au. And thank you again, Paul, and great to talk to you again, Philip. Always good to catch up.
Fantastic. And look, we're going to delve into this whole issue of employment contracts in the future, and also the policies, because I think there is so much in this employment sphere that business owners aren't aware of or just ignore. And look, whenever we talk to business owners, employment issues or whether to employ somebody to start with is up there in the big three issues. So it's very important to get the right advice, to understand what your obligations are, and be aware of the problem. Don't ignore it. So, yeah, great stuff. Business behind your business. For the show notes and past episodes, go to our website, which is www.thebusinessbehindyourbusiness.com, and you'll see the past episodes, show notes, and profiles of our regular presenters. So you'll be getting to find out a bit more about Paul Cripps and Philip Vandenhever on our website. So I encourage you to go there and subscribe to future episodes so you don't miss out on some great advice. Thank you, guys.
Thanks, Paul.
Thank you.